Hello friends, how are you? Namaskaram. Today I am going to discuss section 143A of NI Act. The said section is quite important, specifically when you are going to contest a check case on merits. In that scenario, section 143A might cause impediment or hurdle in your way, because on the one hand, the court might incline interim compensation in your case, and in case of failure, adverse consequences might have to be witnessed by you. So to overcome all the said issues, we have to discuss in the class in the practical way so that we could easily contest such applications on merit. Are you ready? Then be relaxed. Have a copy with you along with a pen or a pencil so that whatever I am going to narrate you may note down the same and could use the same in technical way while contesting such applications. So at the top of the notebook, this part, please note down check matters and then put an arrow. Please note down section 143A NI Act. Then again put an arrow, parameters. First of all, we have to note down the recent judgment of Honorable Allahabad High Court, that is Jaibir Singh versus State of UP. Judgment is pronounced on 17th of April 2025. In that case, the concerned accused challenged the order that is pronounced as per the protocol of section 143A of NI Act. In the said case at hand, the concerned proceedings had been challenged as per the protocol of section 528 of BNSS. The prime concern of the concerned accused is that the concerned trial court had committed the great illegality. Order is perverse, and apart from that, the proceedings are abuse of process. And as per settled legal position, if the proceedings are abuse of process, in that scenario, the High Court may exercise the inherent powers, even though it is to be exercised sparingly, to incline justice and to prevent the abuse of process. To sustain the argument, he submitted that in the present case at hand, the right to get natural justice had been violated. He submitted that it is a right of the opposite party that he has to be heard in support of his case. The same is part and parcel of Article 21 of Constitution of India, which says that the right to life and right to liberty are not general concepts. These are fundamental rights, and if anyone wants to take the same, he has to adopt a process that must be recognized by law, which is usually termed as a due process. Hearing the opposite party is also the part and parcel of right to get a natural justice, which is a part and parcel of Article 21 of Constitution of India. So in the present case at hand, it is emphatically argued by accused that the right of being heard is not given to him. That's why the order is impugned and liable to be set aside and quashed on that point alone. And apart from that, he submitted that there is nothing on the record that the opportunity of being heard had been given to him. He submitted that when at the stage of section 251 of CRPC, he was called upon for the substance. At that stage, without considering his side and even without giving him any opportunity, court directly inclined the remedy under section 143A of NI Act. That is wrong. As we know that section 143A of NI Act is not having any general application. It is to be noted that the word may is used, which is indicating that the power is discretionary, not mandatory. It means the court has to consider the facts, circumstances to decide whether such remedy is to be inclined or not. If the court finds that accused is having the proper defense, and inter alia it comes within the category of probable defense, by the virtue of which the onus shifts on the complainant, in that scenario the court is not bound. So it is my humble request that whenever you are going to contest the application under section 143A of NI Act, do not make your reply in the general way. Make the specific reply. But the preparation should not be from the stage of application. The preparation must be from the stage whenever you are going to give check to the opposite party, means the complainant. Because having preparation after having the case would not provide you any success. And apart from that, there is a presumption of section 118, section 139 of NI Act. So to overcome all these things, we have to be prepared mentally, physically, economically, and have to be prepared on technical issues even prior to filing of the case. Remember this point and emphasize on the same. And apart from that, Honorable Supreme Court in case of Rakesh Ranjan versus State of Jharkhand, judgment is cited as 2024, volume 3, SCR, page 438. The power is discretionary, not mandatory. Even the said judgment had not been followed in the present case. Ultimately, the court set aside the order and remand back the case. So, based on the said judgment, we could draw the 5 important conclusions. Number 1, the Court of Judicial Magistrate, even the executive magistrate, is bound to pronounce judgment containing reasons. If judgment is pronounced and there is nothing regarding the reasoning, in that scenario, the order cannot be said to be reasoned. In that scenario, the consent order can be challenged by relying on guidelines of Honorable Supreme Court, that is Inderjit Singh versus Santosh Kumar. Judgment is pronounced on 19th of April 2022. In that judgment, it has been observed that the consent authority, means a judicial magistrate or the executive magistrate, are duty bound to pass the order that must contain the reasons. If there are no reasons, order will be impugned. Number 2, whenever the order is to be passed in section 143A of NI Act, the opportunity of being heard is to be given. If such opportunity is not given, in that scenario, Article 21 of Constitution of India would be affected, which inter alia incorporates the protocol of right to get natural justice. Number 3, the parameter of Honorable Supreme Court judgment Rakesh Ranjan versus State of Jharkhand, as I told you earlier, is to be followed. That is imperative. And we have to remember that the word may is used, not shall. It means the provisions are discretionary, not mandatory. Point number 4 is that if the proceedings are done in abuse of process, means the proper protocol is not followed, in that scenario, you may directly approach to Honorable High Court under section 528 of BNSS to challenge the proceeding, but it is usually advised to file the revision. So extraordinary circumstances we might go, but in routine we should avoid it. Okay now. And number 5th is that whenever such order is to be pronounced or such applications are filed, you have to observe that whether there is due compliance of section 143A of NI Act on the part of complainant or not. Means whether he has submitted the indemnity, for example, in near future. If the concerned complainant loses the case, then who will refund the amount? So the approach is balanced. The right of concerned complainant is to be protected, and apart from that, he is to be protected from undue hardships. And in the similar fashion, the concerned accused cannot be affected just to please the concerned complainant. In that scenario, if the concerned indemnity bond is not on record and certain protocols and certain indemnities are not submitted, in that scenario, the application would be defective and court is not bound to incline the remedy. So I think that while contesting the case, we have to make the proper reply whenever such applications are filed. Do not contest the case in the casual manner. If you are going to contest the case in the casual manner, in that scenario, your rights would be affected. So we have to emphasize on each and every point so that we could have a proper defense in the court of law and could be succeeded in the court of law. So see you in the next video. Till then, Jai Hind, Jai Bharat.